Sit down. Sit down.
A courtroom outburst from a man who killed the mother of his child with an axe. WTIC capturing that moment on camera. That man was being sentenced to decades in prison, and he had some parting words for the prosecutor who called him cold and calculated. But this is just one of several shocking moments in this case. The Ring doorbell camera here from WTIC showing the murderer with an axe, and the family of the victim is now suing, saying that police could have done more to stop this killing. We're on the case presented by Law and Crime. I'm Chris Stewart. Before we get back to this episode of On the Case, I want to bring you a Law and Crime legal alert, because if you received a Depo-Provera birth control shot and you were later diagnosed with a spinal or brain tumor called meningioma, you may be eligible for a lawsuit. Morgan & Morgan is investigating claims that patients were not properly warned about this risk. It's free to check, it takes just a few minutes, and you don't have to pay unless they win. So scan the QR code on your screen. You can also use the link in the description below, or go to www.forthepeople.com/LCDEPO to see if you qualify. We have some shocking video from a courtroom in Connecticut where a murderer had to be restrained because he was so upset with what the prosecutor was saying about him as he was being sentenced to 40 years in prison. This isn't the first time that Law and Crime has talked about Ewen Dewitt. He killed his ex-girlfriend in 2022 at her home in Milford, Connecticut, with children in the house. Here's a picture of that woman, a mother named Julie Minogue. In fact, she was the mom of Dewitt's 3-year-old son on the night of December 6th, 2022. This is the condo complex where that murder happened. Let's dive into how we got to the point where this man is needing to be restrained in a courtroom as he's being sent to prison until he's in his 80s. Dewitt is an Afghan war veteran. His attorney said that the 45-year-old had PTSD and he struggled with alcohol and drugs. He started dating Julie Minogue in 2018, according to CT Insider, and it seemed like, to some, that Dewitt maybe turned his life around and he was headed in the right direction. At least, to some, that's what it seemed like on the outside. As Law and Crime previously reported, Dewitt had been accused of domestic violence, not just against Minogue, but her children in the past. In 2019, he allegedly threw a playpen at Minogue as she held her infant son. She needed 5 staples in her head. He also faced a harassment case in November 2022 after police say Dewitt sent 200 text messages over 2 days. Then the next month, December 6th, 2022, police say Dewitt took an axe and he went to Minogue's condo and hit her more than a dozen times, killing her. This is a picture from a neighbor's Ring doorbell camera from WTIC TV that shows Dewitt carrying that axe. Police say the couple's 3-year-old son witnessed the murder, and Minogue's then 17-year-old son called 911 to tell police what happened. Dewitt would be arrested hours later in a trailer in a nearby town. It's important to remember, as you hear what happened in this case, that Dewitt had faced accusations of domestic violence in the past. And so there is that question of why wasn't more done to protect Julie Minogue and her family. 5 days prior to the murder, Minogue was given a full no-contact restraining order against Dewitt after those threatening text messages, but as we've seen in so many domestic violence cases, orders can only do so much. 9 days after Minogue's murder, the Milford, Connecticut police chief placed an officer on leave ahead of an investigation into how he handled a warrant application that was not fully completed related to past accusations of abuse by Minogue against Dewitt. The officer's name was Scott Knablin. Now here's a statement from 2022 by the chief per our website, lawandcrime.com. It says, quote, on November 14th, 2022, Julie Minogue came to the police department to file a complaint against Ewen Dewitt for sending her over 200 text messages from November 12th to 14th of 2022, violating the protective order that prohibited him from harassing her. Officer Knablin interviewed Julie and he collected the evidence from her cell phone records that she later provided. On Friday, November 18th, 2022, Officer Connablan completed an arrest warrant application for Ewen Dewitt, charging him with violation of a protective order. Per policy, the arrest warrant application was reviewed by a supervisor, and both the supervisor and the officer believed that the arrest warrant application contained the requisite probable cause to support the charge that the text messages sent by Mr. Dewitt violated the modified protective order that was issued on January 15th, 2021. When court reopened on November 21st, 2022, the warrant application was submitted to the Ansonia Milford State's Attorney's Office. That same day, the Assistant State's Attorney denied the warrant and sent it back to Officer Connablan requesting additional information be provided. WTNH-TV wrote that Minogue had written that she was, quote, afraid DeWitt's going to kill me before her death. The chief said additional information that prosecutors requested wasn't added to the warrant application until December 9th. That is 3 days after Minogue's murder. Officer Connablan would later resign. Minogue's family sued the Milford police, and to our understanding, that lawsuit is still ongoing. As for DeWitt, he faced charges of murder, home invasion, criminal violation of a standing protective order, criminal violation of a restraining order, and risk of injury to a child. Instead of going through a trial, he accepted a plea deal to spend 40 years in prison for the murder of Julie Minogue. And that brings us to what happened at his sentencing. During the hearing, members of Minogue's family spoke, including Minogue's oldest son. He wasn't there the night of his mom's murder, but he said this, per WVIT-TV, to her killer.
You didn't just kill our mom, you exposed what kind of pathetic, hollow excuse of a human being you are.
DeWitt did address the court that day. He said he, quote, snapped, and that he was sorry. The state prosecutor then took to the microphone to clarify that this was not a case of impulse, but this was a planned murder. Remember, you saw that video of him carrying the axe on his way to kill Julie Minogue. And as that state prosecutor was speaking, this happened per WTIC.
Sit down. Sit down.
That's his fault. If outbursts like that continue, I'm left with no other choice but to ask you to remove you from the courtroom and
That'd be great.
DeWitt was restrained and then taken off to prison, where he will be 85 years old, if he's still alive, at the time his prison sentence ends. Joining us now to talk more about this case is practice professor of law at Temple University and former domestic violence prosecutor Marian Bracha. Thank you for taking the time to be with us here today. First, I just want to talk a little bit about this outburst that we saw in court from the man who killed his ex-girlfriend. This was during a plea hearing, so it wasn't like a moment where he was just shocked to hear that he was found guilty. What did you make of just his demeanor in the courtroom?
Well, I mean, I think demeanor tells us a lot. It tells us a lot about witnesses when they appear on the stand. It's part of how judges and juries and other fact finders weigh their credibility, and certainly a defendant's demeanor while in the courtroom tells a lot about their regard for the case, the regard for the officials who are bringing the charges against them, and their regard for the victims or the witnesses who are testifying against them. I think an outburst like this, especially one where it was directed toward the prosecutor, is fairly telling of the defendant's consciousness of guilt, as if his admission and his willingness to accept a guilty plea didn't already tell us that, but his violence and his hostility toward the system, I think, is very telling of that as well.
Just for you, having been a prosecutor, I mean, how do you prepare for the possibility? Because I know there's a lot of trust in the bailiffs that they're going to be around someone who is going to be receiving news that they're going away for a long time. And just as a prosecutor, what goes through your mind? I mean, is that a possibility that ever comes across your mind, that you could be in that type of situation where a defendant could end up getting physical?
There is always the possibility that things could go awry, go and become violent in a courtroom. That has certainly happened. We rely on the hard work and the vigilance of the sheriffs and the bailiffs in the courtroom. In the jurisdiction where I practice, every person who has business before the court, whether they're a witness or a victim or a person against whom charges have been brought, or an attorney who's representing the state, or any member of the defense bar, has to pass through metal detectors and security. And so you're hopeful in that regard that anything that could be threatening or be used as a weapon would have been identified and confiscated at that point. But you're absolutely right. It's as we often say, people don't go to court when they're having a great day. They don't talk to their lawyer when they're having the best day ever. Ordinarily, if someone is in that position where they're in a court of law, especially a criminal court of law, something has gone horribly wrong in their lives. And so there are a lot of emotions, and emotions can come boiling over. And it's just a matter of having your faith in the security and in the law enforcement that is there, designed to protect the courthouse and all members of the courtroom.
And let's talk about this case, because it's a horrific case. This was a mom who was killed. She had 3 children, including a 3-year-old who she shared with the defendant. And according to reports, is the 3-year-old witness this happened, which is just, it's hard to find words to describe that. And part of this story too that created a lot of outrage was that the victim, Julie Minogue, goes to the Milford Police Department and shows these text messages that Ewen Dewitt sent her. And she already had a restraining order out. The police officer then takes a warrant to get approved by the state attorney's office. The state attorney said, need more information, and that information wasn't provided. And now the family's suing, arguing that her life could have been saved. You've worked in a prosecutor's office. You know how all of this works. Like, help us understand this process and how it plays out, and why things weren't done that could potentially have saved this mom's life.
Yeah, it is a rather unfamiliar process for, I would assume, the general public, and it really is dependent upon which jurisdiction we're talking about. So it sounds like the case where DeWitt was prosecuted is very similar to Philadelphia, Pennsylvania, which is where I'm located, which is where my practice was. And what happens is the police are tasked with the investigation. The police will gather witness accounts, they will gather certain preliminary discovery, certain pieces of evidence, and then assemble all of those facts into an affidavit of probable cause that would support the issuance of an arrest warrant. Now, the police would then bring that affidavit either to a magistrate or a judge, or submit it to the state's attorney's office or the district attorney's office for review of the sufficiency of evidence. And remember, we are at a warrant stage, we're at the magistrate stage, so we're not talking about reasonable doubt, we are talking about probable cause. And so that is a legal standard which would give the police authority to go execute an arrest warrant and take someone into custody for charging and then for eventual criminal processing. So it is the duty of the state attorney, or depending on the jurisdiction, the district attorney, reviewing the warrant to ensure that there is sufficiency, to ensure that when the matter goes before a magistrate or a judge for a preliminary proceeding, that there is sufficient evidence at that stage, even at that preliminary stage, to support the issuance of a warrant. I have not seen a copy of the warrant. I don't know what additional investigation or additional facts the state's attorney's office was requesting in this particular case. Sometimes it can be as simple as correcting a typographical error. Sometimes it can be as simple as including what jurisdiction the crime is alleged to have occurred in. Sometimes it can be more significant. It can be a request by the attorney to say, go out and find more witnesses, execute additional search warrants, try to get more interviews done, try to collect more evidence, look and see if there was surveillance footage of the scene. Maybe in a case where we're talking about text messages, the state attorney may have requested phone records to substantiate the claim that these text messages were being sent in a successive and harassing way. So I can't speak to what the request for that additional investigation was, but that is part of the ordinary review process of the state attorney's office, to be in communication with the investigator and say, this is what we need to make this affidavit, or the four corners of this affidavit, strong enough to survive a magistrate's review. And so in this particular case, those requests for additional investigation were made, And unfortunately, it appears that those requests for additional investigation were not acted upon by the detective in a timely manner. And unfortunately, the decedent did not survive long enough to see the issuance and the execution of that arrest warrant.
Yeah, and the officer ended up resigning after an internal investigation, and then the family, it appears, still has some litigation that's ongoing. Because I think of, to our understanding, when Julie Minogue went to the Milford Police Department, she had said that she was afraid that her ex-boyfriend was going to kill her, and then there were these text messages, 200, that were sent. But even in that type of case, and again, we don't have the warrant, so I can't speak to specifically what they wanted, but the bar necessarily wasn't particularly that high to have to go out. Would you say having those text messages, having someone saying that they're afraid that their life is in jeopardy, that would be enough to go to a judge and say, hey, this is worthy of an arrest warrant?
I have to give you my quintessential law professor answer, which is to say it depends, Chris. It really depends on how the affidavit was written. It depends on what information was included in the affidavit. We can't assume that what we're hearing in reports after the fact was actually memorialized in the four corners of the affidavit. So without knowing that, if what you just asked me about the report from the complainant, now decedent, that she felt that her life was at risk, that she was receiving these text messages in a harassing or alarming or annoying way, and that the intent of the messages was to have that effect on her. As long as other perhaps more administrative factors like the establishment of jurisdiction and the identification of the complaining witness in the affidavit, as long as those kind of more basic elements were included in the affidavit, would that have been something I would have approved in my time as a prosecutor? Probably. But again, without seeing exactly how the detective wrote up the affidavit, I can't speak to that.
No, for certain, and we wouldn't want to speculate on something as serious and as dire as this. And I know you've covered so many and have worked so many prosecuted domestic violence cases over the years, and this was another example. And the system potentially failed this mom because she did go to police. But when you look at cases like this, where there's a history of offenses that then lead up to this terrible ending, what can be done when you look at the system that can protect
Absolutely.
people like Julie Minogue?
I really, really thank you and applaud you for asking the question, and I applaud your audience for being interested in hearing this answer, which is to say that to understand domestic violence is to understand that domestic violence is not a one-time incident. Domestic violence is defined as a cycle of power and control. And so domestic violence is an ongoing and often escalating relationship. And domestic violence can occur between intimate partners, boyfriends, girlfriends, same-sex couples, married people. It can happen between family partners, siblings, parents, even, parent to child. So I think the important thing to remember is that we need to pay attention when I say we, the system. I mean, people involved in the system, the police, the state's attorney's office, other stakeholders like service providers, domestic violence advocates, and other victim witness advocates. They need to pay attention when a witness is saying, I fear for my life. My life is in danger, or I fear that it is in danger, because oftentimes these complainants are the best able to gauge the risk that they're at. And so while this may seem like a harassment case, maybe even a stalking case, which in many jurisdictions might be charged as a misdemeanor, there's an expression that misdemeanor domestic violence prosecution is tantamount to homicide prevention. And had this defendant been in custody at the time that he wielded an axe and took this woman's life, perhaps her life would have been spared.
Yeah, it's just a terrible story to think about of what could have been done based off of what we know of what this relationship was like, and what police had already been dealing with when it came to this defendant. He's going to spend 40 years in prison. That was part of a plea deal, so he'd be 85 if he's still alive at the time that his sentence is over. What do you make of because I don't know. I just think you look at this case and you think that this is someone who should be locked up forever. And I know he'll be 85 and who knows if he would even live that long. But what goes into the discussions about plea agreements? Because I also look at that and think of what happened in 40 years. It just doesn't seem like a lot for what eventually, for what actually happened.
I completely hear you, and I would understand why some of your viewers would be frustrated with a sentence or a negotiated plea like that as well. And I think that some of the considerations that are made are for the victim's family. And remember that the victim's parents, siblings, friends, people who loved her would have to sit in court and listen to very graphic, gory, very disturbing and upsetting details about how she was killed, how she died, what the condition of her body was when she was discovered. If the child, the 3-year-old, was a witness to this, and if the 3-year-old was called to testify, there might also be and would likely be a challenge from the defense as to the 3-year-old's competency to testify, which means that the 3-year-old would have to go through what's known as a process called voir dire. They would need to be questioned to establish that they understand the difference between a truth and a lie, that they understand the importance of the oath they're taking and promising to tell the truth. That can be a very long and traumatic experience for children, especially for one as young as 3. So I would venture that the consideration of the prosecutor in this case in extending an offer to plead guilty and entering into these negotiations for the defense would be to spare the family the heartache of the details of this testimony, and to spare the 3-year-old the trauma of having to go through a competency evaluation and testify to something as gruesome as the homicide of their own mother.
And then Marion, just finally kind of going back to what led to his outburst in court, he claimed that he snapped and that's what happened. His defense lawyer made arguments that he had PTSD from serving in the military and then also struggled with drugs and alcohol. And it was after he said he snapped that then the prosecutor takes the microphone once again and says, no, this was cold and this was calculated. When you look at this case, he says he snapped. The prosecution says, no, this was a cold, calculated murder. What do you see when just looking at this case and what built up to the moment that this woman lost her life?
Well, we often say that, the definition of premeditation or the existence of premeditation can happen in the snap of a finger. When you look down and there's a fly or a gnat on your hand and you decide to snap it or slap it away, that is premeditated, even though it seems like just a gut instinct or a reaction to come down on an insect, something like that. So I don't want to be flippant with this answer here, but it is entirely possible for a defendant to claim that he just snapped and this was his reaction, and at the same time for the prosecution to be able to prove or have been able to sustain their burden to prove premeditation. So the two aren't necessarily mutually exclusive, but it's a curious thing that the defendant would have this outburst, having ostensibly participated in the negotiation that led to the guilty plea, and be familiar with the facts and the discovery that would have led to this guilty plea, and then exclaim something that was inconsistent with the prosecutor's rendition of the events.
Yeah, no, it was a shocking moment in court, but the case itself is so shocking in so many ways. Marion Bracha, it's always great to have you on Law and Crime. Thanks for joining us and bringing your perspective to this.
Thank you, Chris. Thanks for having me.
A GoFundMe for Minogue raised more than $156,000 to help the 3 sons who are now without their mom. That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.